Oh, and so here again, Constitutional Crisis Channel. I have another current events video for you, and this one I found out so recently that I don't even have the name of the case, but I'll get back to you about that. But 9-0 Farts just ruled 5-4, with Anthony Kennedy being the swing vote here. And I've heard recently that he might consider retiring, but then again, he's already hired his clerks for the next term, so you tell me. In any event, the court decided 5-4 that employers have the right and the power to coerce employees, quote unquote, into mandatory arbitration for just about everything that happens in the workplace. Now, I haven't read the case, but I can tell you damn well what the majority is going to be relying on. You look at the case, you're going to see probably NLRB versus Jones and Laughlin Steel, 301 U.S. 1, Wicker v. Filbrin, 311 U.S. 117, and some other cases like that. In fact, U.S. v. Darby, 312 U.S. 100, all cases done during the Roosevelt administration. Don't get me started on that one. That exponentially expanded the Interstate Commerce Clause powers of Congress, which parenthetically is a hell of a good trick, given that I can prove that there are no states remaining. Where exactly is the jurisdiction and venue for Congress's Interstate Commerce Clause powers? Damn, this is such a good trick that even Harry Houdini would be proud of it. But to get back to the point, 5-4 mandatory, and now you don't have any right to go into a court. Nothing. Of course, what they don't tell you about that is, and it's a video for another day, but trust me, none of the federal courts that you could go into are judicial courts. And I've got dead bang proof of all of this. The federal, the district court, the courts of appeal, you name it. They are not Article 3 judicial courts. If you try to go into a quote-unquote state court, which I did 11 years ago when I got fired from my job, and I didn't know then what I know now about this, then what happens is these bastard corporations remove your cases. I had it happen to me 3 times. In this case, trying to invoke my rights, we moved into a federal district court that I can't even get into. I'm literally an undocumented enemy alien. Can't even get into the federal building, let alone the federal court. And at the end of the 3rd case, this black robe bitch that handled all 3 of these cases ruled me to be a quote-unquote vexatious litigant. This without any notice, any hearing, no ability to put up any fight, nothing. Couldn't do it. The record shows it to this day, and they took notice of this, by the way, in my South Carolina felony case. And I would have eaten them alive had this gone to a jury trial, and they tried to make a point of the fact that I was a vexatious litigant. Oh, I would have loved to attack that one. It was one of the funny parts. It would be a lot funnier if it wasn't so damn serious in South Carolina. But to get back to our subject matter here, these are the kind of cases they're relying on. And a case in chief here, a later one, on the same subject, is called Southland Corporation v. Keating, 465 U.S. 1, where the court more or less decided the same thing, but in a case where nobody there had any proper status to be before the court, because Southland Corporation, nowadays known as 7-Eleven, is a corporation. They cannot come into a judicial court. They lack standing. Keating probably did have standing, but his attorneys sold him out, and they didn't argue the case the way they should have, describing him as a state citizen with creator-endowed inalienable rights. And the best part of this decision for me is that it was written by Warren E. Bastard Berger, who didn't know his ass from a hole in the ground when you talk about issues of the Constitution. This guy was a total... I do not know how he got appointed to the job. Even the justices he worked with considered him to be one of the worst they ever saw. He just didn't have any ability whatsoever to understand the Constitution or care about it. And this is the Chief Justice? Damn. So you read this opinion, which I don't even have the name of right now, you're almost certainly going to find Keating prominently featured in at least the majority opinion. So we'll see how that develops. But at this moment in time, if you're a worker and an employee, quote unquote, forget about it. Just like with social insecurity benefits, you have no rights to those either. Fleming v. Nestor, 363 U.S. 603, page 609. This is the same type of thinking that goes on with these idiots in Washington, D.C., unless we go there, assert rights, and demand that they obey their oath of office to preserve, protect, and defend this Constitution. That's what has to change. It obviously didn't happen in this case, and I'll have more to report about this the next time we talk. Thank you.